Let's wait a couple minutes. It's not, I mean, for Harrison, let's call Harrison. Can we call him?
Sure.
Do you have his number?
Yes.
Okay,
Yep.
all right, you want to just call roll call to determine that we have form?
Yes. Can we do the Pledge of Allegiance first?
Sure.
Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We can start.
Yes.
Jackie Scott. Harrison Granville.
Here.
Richard Weiss. Chris Burton. Here. Okay, have a quorum.
Just before we start, please, oh, take a snack.
I just sent a message, you can be joining us via Zoom. Yeah. Yes.
The one thing that I was waiting for one day to get, so
That's what he said.
it seems that we just need to clarify. Excuse me one second. We
All
had
right.
discussion at the last meeting, we had discussion. Okay, hi, David.
Good evening.
Hey, we had discussion a year ago, you brought up that some cities do ballot changes or, you know, looking to do it by mail-in ballot, and we had another discussion about mail-in ballots being done for the petition drive and what the cost would be. And just for the point of clarification, it seems that certain people left the meeting last week thinking that by us doing this ballot initiative on this November ballot, that is costing the city $600,000. So David, would you just explain so that it's on the record, what we discussed about ballot initiatives, that we're talking about special, not November elections, and what those costs would be?
Of course, yeah, the ballot only, the mail ballot only initiative was really referring to that if with the petitions, and if we had to, if the individuals did not want to wait until we actually had wait for a November election, then that's what the cost would be for us to have ballot questions on this. It could be a little bit more, just if it goes on to another page, but the total amount with the elections of the mayor and 5 commissioners is about $140,000 total. So that is those were numbers that I put together should we have to have either a special election, or if petitioners wanted to have it on a different ballot than the November.
So the point of clarification, the cost of $601,000 to have a ballot initiative held by mail is solely for a mail campaigns election and has nothing to do with our standard November general election.
That is correct.
And by us being on the November general election, whether it's the presidential or the gubernatorial, what is the cost to the city above what the cost of the election would be? In other words, are we forcing a undue burden on the city?
No, so as long as all the ballot, or I'm sorry, the polling locations are open, it is not an undue burden or undue burden. So no.
And Kenny just walked in. If you just repeat that to Jim, just for one last point, so that he knows and he can report that to the Council of Civic Association, that the cost of the charter changes by ballot in November, what the cost is.
Yeah, so to have the ballot questions on it, we've already budgeted, we have put it into the next year's budget to pay for it. It would be somewhere around 150,000 total. That's including the mayor and 4 commissioners, and if we have ballot questions, and that's worst case scenario. If we don't go onto a second page, then it's about 98,000 or something like that. Don't quote me. I can give you the exact numbers. I just don't have them in front of me at this second. But the numbers that I was talking to, the higher numbers, that was one for a mail-in only ballot. That's if we were to have referendum questions, just mail-in only, and that I was really discussing that as pertaining to if petitioners wanted to have something prior to a November election or something else where all the polls are open.
Thanks, David. Yeah, I was aware of that, but I know there was a couple people that weren't, and they were, I think, usually making an assumption that the higher number, the mail-in ballot number, was the cost of putting this on ballot, right? They
Yeah,
and
that's not correct.
We're good.
Okay.
Thank you.
You're welcome.
Right?
Thank you.
So first, I like to thank you all. We're late in the night. You're calling me and needs some extent to, but you're involved with everybody. We would great. Then, so that's the second point is that personally, I'm comfortable with the report, personally, comfortable with the report because we spent a lot of time. We do been involved in these situations where things are done to the left, and these are for the report. It's really a system information document. Doesn't live forever. It's reported to the city commission. Yeah. Anyway, I felt like at the end, we did the best that we could get. So you know that in the report, it says that my recommendation that all the ballot the charter provisions need to be reviewed quietly by the city attorney's office. Not in a rush, not in, because we think we have it, we think we did a good job and we worked the best that we could, but we did it fast. So that's the third caveat I have is that we put in the report in italic exactly the issue that you're talking about. Because we hadn't had a specific discussion as to whether we really want to recommend that this be heard. Really haven't had discussion about it. So I put it in there to make sure that everybody understood that this, because we really hadn't really that point is that the report is a summary. It doesn't cover every single thing that we touch in this thing, but try to get my points, everything. You feel like there's stuff that should be highlighted in the report that's not in the report, then you can add that. So, having said that, I would just like to start out with having said what I said about the so, have you read, did you get a chance to review the report and get the comments?
Fortunately, I have not.
All right. So, okay, so that we be, so we be productive. So where should we? We find little concepts. We put together, everybody feels like, I thought we would read this meeting done with this section part. So you want to just read the report paragraph by paragraph and that just give you a nice opportunity to digest it and maybe we'll see things that we should do because I think we gotta move this.
Sure, I've already scanned it.
Okay. Do you want, would you like to go through the sections that you addressed at the last meeting? First,
I think we go through the top 6 pages. I think let's go through it. And then if there's anything that comes out of that report that we need to,
Most
bring back.
things that we discussed in previous last,
like 5 or
that
6.
were never really put into charter form that we drafted. And they're covered in summary, but so one of those in summary that will be important to get to the commission. And then
we can go
then
back.
we can go back and
Or if we go on, I can point them out. Go back.
Let's do the report as a whole first, and then we can.
okay, what's the right way to do this? Right. So anyone to do it, but make anybody comfortable. Anyone just take it paragraph by paragraph.
So,
Right. Okay. Yeah. I've read it 100 times. So I question what we need to do there, but it's comfortable. That's feel good about receptions.
I'm happy to start reading it, just to kick things off. And I just wanted to add that, even though I guess we hadn't explicitly discussed the November election, I'm completely in agreement with that statement. Just for the record.
Yeah, I just wanted to be careful because we never voted on it. I don't want to put my own thoughts, and, I just trying to reflect what the committee did, I suppose.
We voted on.
January, February.
Maybe, we were just being cautious.
Okay, that's fine.
Brian.
I need a motion.
Why didn't we adopt the report? No, we should take the italic out.
All right, City of Fort Lauderdale Charter Revision Board report to the City Commission as dated April 11th, 2024. This report contains the first set of recommendations from the City of Fort Lauderdale Charter Revision Board. When further recommendations have been developed, another report will be issued.
Just stuff there, so we figured just to put something in there to let them know that our work was ongoing. This is just going to be like first installment.
And by the way, we started reconvening in January 2022.
Okay. I wasn't sure, and actually, I counted 13. I think 13 meetings. Over January.
And then,
So maybe for voting, but just for us.
So just make it.
Yeah. yeah, but May is when we had
No, I know May is
inspector
one.
general and the attorney's office here. So we started January.
Okay.
Yeah. January.
Since reconvening on today, the board has met on 13 occasions to review the charter of the City of Fort Lauderdale, Florida charter and formulate recommendations to amend it. All meetings have been open to the public and public participation has been solicited at each meeting. The board recommends that a special election be held in conjunction with the general election on November 5th, 2024. the city's electorate to consider. I'm definitely happy with that. The board recommends that the following charter sections be amended as described. The proposed revisions are attached as exhibits, subject to further review and finalization by the city attorney's office. Section 3.0. Qualification members for the charter office. Board recommends that
You might want to have maybe the section also.
Yeah, but let's do the reports. I hold them. If anyone has questions, we can answer that.
The board recommends that section 3.03 be amended to clarify that employees for mayor and city commissioner must, one, have resided continuously in the city as a permanent resident, but as permanent residents for at least 6 months preceding qualification for office. Two, the electors of the city at the time of qualification, current charter requires that they be over the age of 20. Not hold other elective office or be an officer or employee of the city at the time of filing to 0.14 of the chart. In addition, with regard to candidates for city commissioner, it is recommended that the charter be amended to require that candidates shall have resided continuously as a permanent resident of the city commission district for which such candidate seeks office for at least 6 months immediately preceding the date of qualification for such office. However, in any year in which there has been a reestablishment, reapportionment of city commission districts, a candidate whose permanent residence in the city is in a different district as a result of the reapportionment may seek office in the district of his or her permanent residence that results from the reapportionment, notwithstanding the 6-month residency requirement. The board's recommendation for section 3.03 is set forth in exhibit.
Well, I have a question. 1, 2, and 3 are new. There's nothing in the charter about an officer employee of the city right now.
There is, but the date from which it's measured is changing.
Say, talking about that we can't.
It's in the charter currently.
It is,
And you can't be a city employee.
right, but we're clarifying at what point in time.
Right.
We're qualifying that. It's at, what we're adding is at the time of filing the candidate oath.
So that's different than what it is now.
There are 2 changes. One change is it was 6 months prior to the election date.
Right.
The other point was, it used to say 21, we're saying being an elector of the city, which can take it down to 18, whenever the legal age is to be a registered voter.
And it's probably,
Those are the 2 changes.
written when, before the voting age was lowered to 18.
Okay, so the number 3 is a change.
Because of the time of
Because of the
filing.
time.
Section 3.04, judge of elections and qualifications of members. Pursuant to section 7 of chapter 2012-253, Laws of Florida, also known as the Special Act, the Broward County Canvassing Board canvasses all municipal elections in Broward County. Inasmuch as judicial remedies exist for the potential challenges as described in section 3.04, violation of the charter or qualifications to hold office, the board recommends that section 3.04 be repealed. The board's recommendation in repealing section 3.04 is set forth in exhibit 2.
That would put us in compliance with the state law.
We discussed.
Section 3.05, designation of vice mayor. The board recommends aligning the timing of the designation of vice mayor with that of seating a new city commission following a regular municipal election as outlined in section 3.09. In addition, the board recommends adding language to provide for redesignation of a vice mayor in the event that a vice mayor does not complete his or her term of office. Board recommendation for section 3.05 is set forth in exhibit 3.
I had a question, Paul, about this. If there's a, if the vice mayor resigns, I guess that's, the vice mayor resigns and we have a special election to fill that spot. So that would, the second sentence would take care of that, in the event the vice mayor does not complete his term of office.
Not necessarily, because there's that 18-month rule in 7.0 something in Article 7 of the charter. If it's more or less than 18 months before the next general election.
Okay, what I'm saying is that the board recommends aligning the timing of the designation of the vice mayor of that seeking new city commission following your regular municipal election. What about a special election?
I believe the way it's written.
Talks about it. I'm sorry. Next line.
I would move that you have permission to talk anything you want.
I don't know. I was looking at exhibit 3 and it looks like the underlined section on exhibit 3 addresses that. However, in the event during the period between regular municipal elections, the vice mayor leaves office and a new district takes office, the substitute commissioner. At the first regular meeting after the substitute commission takes office, the city commission shall by resolution.
So we dealt with it in the ordinance, in the charter, but we didn't deal with it I think it's as much detail as we need in this summary.
Yeah.
It's a very minute point.
Section 3.08 forfeiture of office. The board recommends deleting the sentence that provides for forfeiture of office in the event of a conviction for a felony in light of and recognizing the existing governor's statutory authority to suspend and remove municipal officers. The board's recommendation for 3.08 is set forth in Exhibit 4.
Again, that would put us in consistency with the state law.
3.09 organization meeting. The board recommends that the organization meeting of the commission following a municipal.
Well, should it be organization or organization?
The current charter says organization.
No, but it's telling you in our little report.
Term may be used. I think that can be organizational.
I think it should be organization, just to read better.
That's the old language. Let me check though to see if the term is used elsewhere in the charter.
So the board recommends that the organizational meeting of the commission following a municipal election, regular or special, at which those elected take office, be on the date of the first regular city commission meeting after the certification of election results by the Broward County Canvassing Board. See section 3.13.
Remember, we were capitalizing, maybe we should use our capitalized term here for regular meetings, right? Remember, because we were capitalizing regular meeting, that was in the ordinance, that was in the actual charter language. But we've defined a term, a regular meeting, so there can't be any.
Yeah.
And so should that be regular meeting?
I'm sorry, I was writing something when.
Okay,
Where is
it
that?
says in the third line down under 3.09, the first regular city commission meeting. Should we just say we have a defined term, capital R. Regular, should be just regular meeting.
But remember, actually we defined it as meeting, including both of them.
Right, but this is, the
So-
swearing in occurs, we did both. We defined a regular meeting, we defined a special meeting, and we have combined them both to the board meeting. So the board and this organization meeting following is be at the regular, isn't it the first regular meeting? That's what we wanted this morning.
Yeah, it says here, on the date of the first regular city commission meeting
Yes.
in 309, but we have not capitalized the regular.
For the report, I don't know that it's necessary.
So what we did is when we started dealing with another issue, we went back and started doing some more capitalization. These are the kind of things that need to be, we were doing it at midnight on Sunday night or something.
But I don't know that we need to capitalize it in the
Okay, it's fine, just leave it. It's correct.
3.09.
It's not incorrect. It's right.
Because then we give special definitional
Okay.
significance to.
Yeah, what we might want to do though is capitalize what the parenthetical language regarding C313 regarding capital, initial caps, regular meetings. Yes,
One question.
we might want to do that.
Does this limit us to taking the oath of office at a night meeting versus going back to that?
No, I mean, what with, the way that the charter version is drafted is that you have regular meetings, which are on the first and third Tuesdays. Except if there's a holiday, in which case it flips over to Wednesday. And they have special meetings, which could be called by the city commission at any time. If ordinances, resolutions, and motions must be heard after 6 o'clock. In any event, but we don't say, in other words, I think that to this, you could swear in somebody at noon. As long as it's part of a because it's part of a regular meeting.
I just wanted that clarity that if you want
But
to do it
should we
earlier
call-
in the day,
Yeah, I
as long
agree
as it's the same, day of the regular commission meeting.
Part of a regular meeting, but the regular meeting is divided the way that the city operates them, I understand, in two parts. There's a part A of the regular meeting where they discuss stuff and they whatever, and then part B of the regular meeting is where they actually take action. And all the actions must be taken after 6 o'clock. But I think they could swear somebody in as part of the regular. You agree?
I agree, because it wouldn't be a motion, resolution, or ordinance.
Just a swearing in.
Right, it's just giving an oath of office. Which you
Okay.
can do even without the meeting.
And I just did a word search, organization doesn't appear in original charter.
Organization,
Organization, no.
well, that's what we're changing to see if organization meeting is there.
Okay, let's keep going.
Thank you.
Section 3.10, special meeting to seat a new member. The board recommends the repeal of section 3.10 if the city commission adopts the board's recommendation for section 3.09. Section 3.10 will be superfluous because section 3.09 will prescribe the time of taking office for officials elected at a special
I
election.
think all they should say city commission adopts it, the electorate approves the amendment.
Yeah.
310, not the city commission.
Why don't we say on the vote and
Whatever, that's fine. Electorate. That was what was tricky about this, to do it fast, because a lot of these sections interlock
Yeah.
with each other and play. So that's why I want them to have the chance to get it.
An organization only appears once.
organization meeting.
Yeah, it's not in it.
Aren't you a fountain of knowledge?
I'm putting types.
How many times, Anthony?
Sorry,
How many times you said?
just the one time.
Organizational or?
Organization.
I see it twice.
Where did you see it?
Section 3.09 and section 2-219.
2-2?
Dash would be an ordinance.
Yeah.
Oh, that's ordinance. Well, I'm just saying it cross references of ordinance then.
Okay, well, that's good to know.
I don't, after this charter, they're gonna have to, these charter amendments pass the city, they're gonna have to go back and go through the code and see what else is. Yeah, okay.
And just because I didn't see this line before, the board's recommendation for section 3.10 is set forth in exhibit 6. Section 3.13, meeting place, meetings to be public. The board recommends amending section 3.13 to provide for, 1, the holding of city commission meetings on the first and third Tuesdays of each month or the succeeding Wednesday in the event of a legal holiday. 2, rescheduling meeting dates. 3, calling special meetings by resolution. And 4, the agenda to be established by the city manager. And 5,
Get rid of the other and.
You have to number 3, right?
Yeah.
and 5, to provide for the city commission by ordinance to prescribe rules of parliamentary procedure and identify a parliamentarian. Board's recommendation for section 3.13 is set forth in exhibit 7.
Quick question. When you, in other municipalities, you identify parliamentarian, is that going back to one of the other cities, is that someone that the city would need to hire, or someone that they would need to designate from existing staff?
A lot of times it's the city attorney. And that's, we mostly are.
Which
But I don't think it's to hire anybody.
There's a couple cities that have, so that is, yeah.
Section 4.05, city manager appointment, qualifications, and compensation. The board recommends amending section 4.05 to require that the city manager be a permanent resident of the city during his or her term of office. The board recommendation for section 4.05 is set forth in Exhibit A.
All right, can I interrupt for a second? I'm sure.
Yes, please.
I believe this was the order of your discussion. Would you prefer 4.05?
Yeah, it should be
follow
moved.
three?
Yeah, it should go in the correct order.
Yeah.
Section 3.15, initiative petition for proposed ordinance. The board recommends restating section 3.15 almost in its entirety, related to the initiative referendum process. The proposal excludes budgeting, salaries, taxes, and zoning from the initiative process. The recommended procedure for both initiative and referendum is as follows.
Should be a referenda or referendum.
Initiative is also
Initiatives, singular.
Should be in both initiatives and referenda as follows.
Okay. 1, proceedings.
I'm sorry.
Sorry.
1, proceedings may be commenced by a minimum of 10 electors who file an affidavit with the city clerk stating that they will constitute the petitioner's committee rather than the current requirement of a committee of not less than 1,000 electors to initiate the process. 2, the committee submits its proposal to the city attorney on a form provided by the city. 3, the city attorney has 30 days to find that the proposal is legally sufficient or insufficient. 4, the committee has 30 days to resubmit the proposal in response to a finding of legal insufficiency. 5, petitions must be signed by at least 1% of the total number of electors registered to vote in the last regular city election. 6, signed petitions are submitted to the supervisor of elections for verification. 7, upon receipt of a certificate issued by the supervisor of elections that the petition is sufficient, the city commission considers the petition.
Paul, should we say in number 5, in order to be sufficient, petitions must be signed?
The sufficiency is.
I don't think that's not sufficiency, that's.
Okay, but where are we saying here? It says petitions must be signed by at least 1% of the total number of electors. For what? For what? For what?
I was going to ask this question because we were basing everything off 1% of the prior November general election, which is the normal process when you're doing petition drives, versus saying to vote at the last regular city election in case something comes up where we end up having a special election when you're
It says 1% of the total number of electors registered.
registered to
I
vote.
understand what you're saying, I need to see whether the chart uses the term general or regular.
And that's where I was going. I believe that would be the general election. Chris?
Well, I had a different issue. I thought it was 1% of the people who voted the last election, not the people on the rolls. Because remember, we're going through how many people voted, and we got that 126,000,
It was
130,000.
132,000, which 1% would be roughly 1,300 people. Versus currently it says 1,000 people.
No, I understand that, but the 1% here is registered to vote. That would be the entire voting roll. versus.
Well, 132,000, no, wasn't that that was based on, I have it. I have, that's what we looked at that time. I think that was the number of registered voters at the last November election, not those that voted. No, this was like 90,000 that voted in the mayor's race, so you just pull
While
it.
they're doing that, but I think five needs something saying petitions must be signed and what? In order to, I think it needs to say in order to be sufficient, petitions must be signed by at least whatever the number is.
Isn't that redundant when you say petitions must be signed? They're not.
Not only that, but if they
I
have.
mean, I had what,
You
petitions
heard.
must be signed by 1%, and what if they're not?
It
Well, but the-
qualifies.
It doesn't say that, it doesn't
Section-
say in order to be sufficient.
But the charter, the proposed charter section says. Number of
Oh, I
signatures,
understand, I'm just saying to be clear in the summary, if you think it's clear, it's fine, I understand it. But I just wanted to,
because we don't give any further direction in this section itself, right?
okay, if you don't think it's necessary, I'm fine. I mean, the charter, or the actual charter version covers it, but if you don't think it's necessary, it's fine.
Let me just address general versus regular. Section 7.07, the title or catch line of the section says. General election, semicolon, regular municipal election. But it says, beginning in the year 2020 and every fourth year thereafter, a regular municipal election shall be held on posted after the first Monday in November. So I think it's pretty clear that the charter uses the term regular, and this is probably where I got that from.
And it says regular election in 3.5.
Says regular.
Yes, it's, so.
That's coming out of 707.
Petitions must be signed by at least 1% of the total number of electors registered to vote at the last regular city election.
Regular city, this is regular municipal election, but. That existing language, or is that something you're changing? I think, but you're.
That's the draft amendment. I have to look up the
In 3.0.
3.15. That's in exhibits. Yeah.
Said like at your fingertips.
And the original charter language in 3.15 doesn't.
Yeah, it
address
doesn't because it said 1,000.
Yeah.
It gave you a number rather than referring to elect.
I have to imagine that, the city's population is what, 180,000, give or take. 130 does sound like the number of registered electors.
Yeah.
We never get 100% turnout even with us.
Well, we just look at the election results from 2020.
I had 132,766.
Yeah, and the last time in the general election of the mayor's race in 2020, there was roughly 90,000. It was 85,000. Yeah, it was 85,000. change.
956.
Yeah, so the 132,000 would have been those that were registered voters in the city.
Still.
Mhm.
So it's a little sad.
Shall we wait for Richard?
Yeah, because I have a question that I'd like him to hear.
Yes, the total voters, 132,766. With
That's not registered.
85,000, yeah, that was registered.
Oh.
85,956 voted.
So which one did we agree on?
I think we did agree on the registered voters.
You're registered voters.
So I have a question.
Yes.
Would it be better to say though, in as much as section 7.07 use the term regular municipal election, might it be better to say at the cities, this is the second line of E1, at the cities, at the city's last regular municipal election.
My only concern is what if we have a freak accident where we end up having a special election in the middle of the year that's not in November?
But do
And then
you,
that throws it off.
but do you
So,
want to use that count? Do you want that count to be?
no, I'd rather use the count of the last general election registered voters,
Right, but that's what I'm saying, since
which would be November.
Since it's already used, the term regular municipal election, should we not say?
I was agreeing with you. He's saying.
I think we're saying the same
Should
thing.
use a free election.
Should it, I think it just wordsmithing, I think it may read better at the city's last regular municipal election. As compared to at the last regular city election.
Well,
I think the proposed change is clearer, because now that you said about that loud, the former does sound a little bit clearer.
Don't forget, a lot of this comes, this was borrowed, some of this. At the. Is that okay with everyone? At the city's last
no,
regular
I
municipal.
mean, I just
So
looked at
there-
the last general election.
Just for reference, there are references to special municipal elections in the charter, so I would think there's a.
Right, and this clarification, this makes it clear that it's the last quadrennial one.
They're gonna have to go through this entire thing, Anthony, and just make sure that we're not messing something up and that they've considered all the other provisions that we haven't even talked about and that might impact what we're doing.
What is the variance between the registered voters between either election? Is there going to be a great variance? You're talking about the registered
Probably
voters.
not.
Yeah, I mean, I don't think so, so.
Most people are registered, they sort of stay registered.
Exactly, that's what I'm saying. I don't think if we're looking at,
You will have
well,
I'm in a new world. Okay.
For clarity, should I make that change
I don't really don't have an opinion on this.
or just leave it?
Are we talking about the previous change suggested?
What I
thought
just- At the city's last regular municipal election.
I think that's fine.
That's fine. So return to number 6, signed petitions are submitted to the supervisor of elections for verification. 7, upon receipt of a certificate issued by the supervisor of elections that the petition is sufficient, the city commission considers the petition. 8, if the city commission fails to adopt a proposed initiative ordinance without any change in substance within 45 days, or fails to repeal the referred ordinance within 30 days, it shall submit the proposed or referred ordinance to the electors of the city.
And those numbers should probably be spelled out in words, 45 and 30.
Number 9, the vote of the electorate is held in conjunction with the city's next regular municipal election, unless the committee elects an earlier vote of the electorate, either in conjunction with an earlier available Broward County election or by mail ballot election, provided that the committee shall prepay the cost of a vote of the electorate that is held earlier than the city's next regular municipal election. 10, if a majority of the qualified electors voting on a proposed initiative ordinance or on a referred ordinance vote in favor of the measure, it is considered adopted upon certification of the election results. The board's recommendation for section 3.15 is set forth in exhibit.
A a grammar noun verb question, since really a majority, singular majority of qualified electors, should that be votes,
Where are we looking?
what you just read in ten?
I
Majority
think
of
vote sounds correct.
vote sounds good.
Majority vote.
Okay.
Section 8.01, sale of personal property, procedure, public notice. The board recommends amending section 8.01, requiring that the procedure for the sale of personal property belonging to the city shall be as provided by ordinance.
I'm gonna add a comment after 8.01,
So we punted on this.
right?
We basically
Yeah.
said, let them deal with it.
That should add some punctuation there.
Yeah. And I don't, so the board recommendation for section 8.01 is set forth in exhibit 10. Section 8.02, sale of public lands and public property to public bodies. The board recommends amending section 8.02 to outline the process of selling or otherwise conveying city-owned property to public bodies or allowing public bodies to make improvements on a city-owned property. The use would have to be for a paramount public purpose, to wit, an activity that is essential to the health, morals, protection, or welfare of the city, or for use predominantly for educational, literary, scientific, or charitable purposes as determined by the City of Fort Lauderdale City Commission. The board's recommendation for section 8.02 is set forth in exhibit 11. Section 8.04, sale of real property to private persons, firms, or corporations.
So we're gonna do it this month. We have a place.
We didn't settle on this. We didn't settle on this, and there is a proposal.
So we're gonna discuss this.
Yeah.
Discuss the substance, so we'll come back to it.
Yes.
Let's keep going.
Section 8.09, leases for more than 1 year and not more than 50 years. The board recommends amending section 8.09 to clarify that all use agreements, including leases, license agreements, concession agreements, facility use agreements, and other types of use agreements, each is an instrument with private parties for the non-public use of real property owned by the city are subject to a 50-year maximum, including any renewals or extensions.
May I?
Yes.
Jack?
Yes,
Okay, one
please.
of the things that you asked me to do on 8.09 was to make that any use. So from the section, I deleted the word non-public. So that should be consistent, right?
Right.
Remember that? Well, I'll go over the changes later. That was one of the things.
The city commission's approval of an instrument would be subject to the following. 1, approval of any instrument having a duration exceeding 1 year would require a resolution adopted by the affirmative vote of at least 4 commissioners containing a finding that such use of the property would be in the city's best interest and the city commission's consideration of a fair market value analysis of the property prepared by a qualified independent consultant. And 2, in addition to the requirement of a fair market value analysis described in number 1, the approval of an instrument having a duration exceeding 10 years, including any optional renewals or extensions, will require the city commission's consideration of an accompanying business viability report prepared by a qualified independent consultant.
Check.
Yes.
I believe economic feasibility is still in there. Economically feasible also is in there. I don't know if you still want that. Because the section says, based on a fair market value analysis of the property prepared by a qualified independent consultant, that such use of the property would be economically feasible and in the city's best interest. But I think there was a discussion at the last meeting. And I think, Richard, you may have deleted that term, or suggested deleting that term from the report, but currently it's still in the section, economically feasible. I guess by the same consultant that does the fair market value analysis. I don't know if that's what you
And-
want.
Let me just ask for clarity. As a layperson. Is the language clear enough to understand that the developer is not the one that's paying for this independent
It's not.
consultant?
It's not.
That was my concern. So
Yeah, because I think one
they
of the,
can't come back and say, well, we did the report and here it is.
I think I may have raised that at the last meeting.
And maybe Pat Riley wants to,
Yeah,
then,
who's consultant?
Pat,
I would say that, of course, the city will get who they want to get, and, the developer is going to have someone that is going to present why they think it's feasible and economically feasible and a good project. So, my experience so far that we have in the city here is that we go out and get who we want as a consultant. Is that what your question was?
It's a fair point. I think both consultants should be hired by the city.
Don't forget, there's also a
Oh.
second component, which is the business viability report.
That's what we're talking about.
No,
Two consultants.
Two
One
consultants.
consultant is the fair market value analysis. The second one's the business viability, and both of them should be done by consultants hired by the city.
yeah, I just think that needs to be clarified in
So
this.
we need to change that in the report. And
Pat,
also-
you're comfortable with what we're saying?
Well, I don't want to be a voting member here, but I think personally, that's the better way to do it,
Yeah.
where we decide to have it for both.
So my
I think
point-
I think that's, yeah, Anthony,
Do you want to say at their expense? If we hire, they pay? Or is that too granular?
We can discuss that.
I wouldn't,
Well, I think that if they're doing some sort of an agreement with these people,
yeah, that's.
then I would include in the agreement that they're gonna reimburse us for the expense. I mean, if they're on the ball and they know that it costs money to do these things,
Cost
Except
recovery.
that you don't have an agreement yet, though. This is a condition of having the
So the
agreement.
question is, what if these people come back and say no?
Well, let me just say with the P3s, the proposer has to put in a $25,000 deposit, and I believe the language is added, if that's not enough, that additional costs for those type of services can be requested.
Jim, you
We,
want to say
we,
something?
we never talked about, I agree with what you're saying. I think it should be in the language that they pay for it. But I don't.
Well,
think
you're
we really
talking
discussed
cost
it the last time.
recovery versus putting in that.
No, we didn't discuss it
Yes, sir.
last time, but I think it's a good idea to put it in.
That's what I'm saying.
Yeah,
I just want to make sure the clarity, because I've been through that on Bahia years ago. And I remember the disputes during the one-stop shop as to whose consultant reports are correct.
It's a consultant hired by the city at the proposed, whatever we're gonna call the people expense. Right?
yeah, so.
If the city's smart, they'll ask for the money to deposit up front, but it's clear that it pays for it.
So I'll make a motion that we amend section 8.09 to include the city will appoint both experts, as the case may be, and that the developer will be required to reimburse the city for expense of the independent.
Yeah.
evaluation.
Reimburse or just make them pay?
That's up to the city. They have to pay. So it's up to the city if they, can't write everything in here.
No,
Right.
So it's,
you can't.
it's at the expense of the, whatever we call these people. And so if the city says, the city's situation, what could happen is that the economic analysis comes back poorly and the guy walks away. Or the city would be silly not to get the money up front. I mean, I would, if you want something from the city, give us a deposit up front. We'll do the analysis. give us a check up front. But if the city, that's up to, I mean, there's gotta be some management here.
I agree. I just think we should put into 8.09 the fact that
So they pay
the city appoints their own,
only points and then they pay.
they pay.
With the rest.
That's gonna take some
Reserving the
drafting
right for
clause. We don't have a defined term for the person
Right,
asking
just for my notes, I put lessee, but
something.
we'll come up with something else.
Okay.
Section 8.21.
Wait, there's a motion, did you wanna?
Oh.
Okay, I think
A
there's a
second.
Second that. All in favor?
Aye.
And at the risk of belaboring, probably we go back to my original question, and that was the first consultant doing the fair market value, the way it's drafted now, that includes economic feasibility. The second one is business viability, but did you want to get rid of economically feasible or?
I think the first one we're saying is fair market value because it's for short term.
And in the city's best interests?
Both should be in the city's best interest. Both should be, the city commission should never do anything. That's not-
But the second one is more, is business viability with the business work.
Right, but that's another layer of examination that they're gonna have to pay for.
Okay, but on the first one, the first consultant,
They're just doing a fair market value analysis. No, they're not doing any,
what about city's best interest?
definitely.
You know, you
But not-
comfortable with saying would instead of shall.
Well, it's in advance, so
But
the consultant is doing the study and the requirement is that the consultant has to say that the use would be in the city's best interest, no?
city commission has to find it. It's the city's best. That's a job for a consultant.
So-
So consultant says this is a piece of property, city's leasing it to these people for 3 years. I think the fair market value is this. That means that the lease payment should be that. And then it's up to the city commission to either to ignore it, if they want to, but at least it'll be in front of them.
Because it is conditional.
But
But so I'm gonna take out economically feasible on the first
yes,
consultant and leave in the city's best interest.
Pat, what is the proper term for economic viability of a business? Is it business, it's a successful business plan? Is it economic viability? What is the right term if we're having an independent person look into what they have planned for the property? What's the right term to use?
Got to think about that one. I mean, it's usually, you're looking to see if they have the, ability to do such a project. Let's say if they want to build a $200 million project, do they have the, the experience and the financial and history of doing this in the past, and all those kind of things. So does the company or the proposal have a, I'm trying to think of the right word too, really in general, the overall ability to perform this project. I'll have to think about that, what the exact word would be.
Isn't it more, Madam Chair?
What?
Pat, isn't it more a matter of the expected success of the business and income and revenue and the survivability of the business?
Well, that's part of it too, but it's first is like, somebody comes in and do they have the ability to do it? Do they have the ability to get the financing? Have they done this before? Have they had any issues with doing projects like this before? And then of course, you would definitely want to know, is it something that would, even hurt the city if it was a failure? So those are two factors. Well, I don't know about too much about that one, but.
Pat, what we're trying to look for is a term. Right now, we say business viability. Is that the right term, or is there some other term we should be using?
I think that kind of covers a lot that would be understandable by most people to say that.
Here's
they
my
have
question. If we hired a consultant and we said, we want you to look at this project and determine business viability, would that encompass qualifications of the developer, ability to do financing, cash flow, blah, blah, blah. Would that be enough of a buzzword so that they would know what to do?
Well, I
Second
think
copy.
that, I think that covers the, sort of the success part of the project, but the part of do these people have the capacity and the ability to do it might be a piece of that. It might be twofold thing to say.
You know what, though, if I may?
Yes.
This term may be okay, because that would be fleshed out in the scope of services in the consulting agreement. With the city, if it's if the person or firm is hired by the city, there would be a consulting agreement, there would be, I guess it might be competed.
So what if we added the words, qualifications of the proposer and economic ability of the project?
Anthony, you lived through the one-stop shop when you were a developer, and this was the major sparring issue of that failure to have a business plan and the viability to get the financing to do the deal,
So how
which
about,
we've seen
how
today.
do you
That's
feel like
not that-
about qualifications of the proposer and economic viability of the project? How do you feel about those things? What do you think, Patrick?
Yeah, I like that, like that better, because usually in a even just large purchases that we do, we have a major section on minimum requirements of the proposer, and then the requiring them to give us a business plan on how they're going to do it and the viability of if there's going to be revenues related to it, to explain how the business side of it. So it's both having the business side of it and also the capability and the experience to do that before you would even want to think about, looking at it.
Okay, so let's do that. Qualifications of the, whatever they're going to call
Whatever
it.
the term.
And then, economic viability of the project,
Business viability.
business
We
viability.
need to
Right.
do anything.
What happened?
That's probably David saying, fix the screen.
Don't know why it's doing that.
No,
No.
What happened to the audio visual back there?
Yep.
Wasn't he here, the audio visual?
Yeah, I think there's equipment in the other room, so it goes back and forth. So I'll check.
All right, let's keep going. We got it.
Okay.
I'm sorry, where exactly were we? We had section 8.21.
We didn't do 3 yet.
Oh, I'm sorry. So back to section 8.09, subsection 3.
Hold on a second. So that part of the report will also be changed.
Yes.
Each instrument shall contain a provision prohibiting assignment except upon the affirmative vote of at least 4 commissioners. Board's recommendation for section 8.09 is set forth in exhibit 13.
Since we're gonna live with this word instrument forever, is that a good word? Doesn't really.
Well, they're not all releases necessarily.
They're all agreements. Is agreement a better word? The word instrument, just, I don't know, it just like, doesn't feel.
Instrument is used in section 4.01 charter. In different contexts, but instrument is used in charter.
I think agreements is a better.
Agreement, I think so too. I think let's just change it. Just instrument just doesn't, that's what I know we came up with it. One night, you and I, late at night, but I don't like it.
You want to see what 4.01, what I'm referring to?
No, I was gonna
4.01?
call it an agreement. Sorry. Don't mean to be snippy, but okay. Let's go.
Section 8.21, disposing of park property. The board recommends amending section 8.21 by deleting the first paragraph, which is a superfluous statement of the city's right to dispose of public property. In addition, the board recommends 1, that the city not dispose of land zoned parks, recreation, and open space, except as may be approved in a referendum at a special election called pursuant to section 7.11.
What is 7.11?
Oh. That is special election for other
Why
purposes.
don't we just say,
Have it
at a special election period? Why don't we put a period instead of?
There's a reason for that. It's special elections for other purposes. In other words, other than nomination or election of a member or members of the city commission. So it's an election for anything other than candidates. So I think it makes sense.
Okay, that's fine.
Two, that the city not lease land zone parks, recreation, and open space except pursuant to a unanimous vote of the entire city commission. And three, that the date of November 10, 2004 be removed from the charter, resulting in the requirement that a unanimous vote of the entire city commission would be necessary to remove the parks, recreation, and open space designation from any parcel.
Yeah, I struggled with that one. I mean, what you suggested was great, but this, I struggled with describing this.
That's it.
Four, renaming this section, the board's recommendations for section 8.12.
Well, I wouldn't put in for it because we're gonna have to rename, a lot of these sections are gonna get renamed.
And I have a question for you, I'm boiling. In the introductory paragraph of 8.21 in the report. Is superfluous a little much? Should it be unnecessary? First sentence, first paragraph of 8.21. Second line. Is that a little much? Should it be unnecessary statement?
I think yes,
Doesn't matter.
nervous is a little strong.
We're done.
I don't know if it's redundant, but
Superfluous says that we don't need
they don't need
Yeah.
it, so, okay. That's what I was thinking.
I like it.
Okay, just a report. Okay. That's that.
Okay. Do you want to hear, do you want to do anything further on the report or vote or anything?
I think we should hold off voting on the report until we see if there's any other little changes that we'll make on any of these articles.
All right,
When
so
do we have to get this to the city now? What's the time?
To be honest. Tomorrow. Tomorrow.
Then don't we need a vote to,
No, but I'm saying, I'm just saying that we're gonna go
Towards
through
the
the
end of the
articles that we're
year.
dealing with tonight,
yes,
and we're gonna,
do you want to meet on Monday?
no, I think we can, I think once we make, if there's any change that made, we'll tell Paul just to correct the report.
okay, fine, I don't have a problem.
Well,
I think we're pretty clear.
we just have to address the placeholder on
Yeah.
section 8.4. Yeah. I don't know if the board would like to do that first. Or if that's
that first.
So what I have to say on 8.4 is the board did not reach a conclusion on this section, but at Richard Weiss's suggestion, I reversed the order of the threshold amounts, made the smaller one first. And this is the one where I guess we're not prepared with the list of properties unless Anthony has it.
I'll try to find it.
But remember I said this was kind of a random. Anthony can give us an idea of what size and what value properties there are. And so based on that list, I kind of came up with a random cutoff. And that was a million square feet, exceeding a million square feet or exceeding $1 million in value will require the affirmative vote of at least a 4/5 majority.
So that implies that anything smaller than that
Would be a majority.
be just a majority. Okay,
Now,
so
do you want
let's
to make
just
that 4 votes
stop.
like we,
Let's just stop there for a second. Are we comfortable with that delineation? Which is that if it's under 1 million square feet, right? Or $1 million in value. It just is a vote, so they can sell real property to private parties. That is worth $999,000. just on majority vote. Is that what are we? I'm not being, there's no English on that question. I'm just asking the question for discussion.
And let me just reiterate, those cutoffs are random
You know, that's what we're talking about.
in the draft.
I think last
I
time we
think-
talked about the disparity between the $1 million and the million square feet. 1 million square feet is 22, almost 23 acres. It's huge. Yeah, that's a huge piece, and you're not gonna find any property of that size for anywhere remotely near $1 million. I think $1 million is the threshold, not the.
Let's just look at it the other way, which is how expensive a piece of city property would we feel comfortable with in selling? Do we feel comfortable that a majority of the commission should be able to sell a piece of property that's worth $500,000? Just by majority vote? We do.
I would think so. What I'm saying is that
Yeah, my interest is the larger parcel, so.
Okay, but I'm just trying to, what do you think? Okay, how about $1 million?
I think that's a good threshold.
Okay, so maybe we should forget about the square feet and just say property with a fair market value of less than $1 million. It just is a majority vote.
I agree.
Over $1 million up to 5 million requires a 4/5 vote. And over $5 million requires what, Paul? A majority, vote of the electorate. Over 5 million.
Wait a second.
What are the size of the parcels that actually the city owns and property that would be available?
That's what I'm trying.
Yeah, there's a list that we got in risk management.
Oh, okay, over 5 million. Related property exceeding 5 million. So between $1 million and 5 million. How does this work? I'm getting lost.
So anything less than $1 million.
Yeah.
Is majority.
Okay,
Between $1 million and 5 million,
right,
it would be 4
4
votes, would be a supermajority.
and over 5 million.
Over 5
is
million would be
unanimous.
require unanimity.
This is radical, but I think it's, but it's been protects.
Jim, you want to take something?
I just wanted to say that during that discussion, several people were concerned and brought up the fact that by making certain thresholds, you may discourage developers. And is that something we want to do?
What do you mean discourage developers from having to get a majority vote? Would unanimous vote?
Yes,
Well,
we're creating barriers to entry.
Currently, the charter says that you need unanimous vote for the lease agreements. We've reduced that down to 4 votes versus unanimous votes. We have not seen how that has discouraged developers from coming in and showing interest on deals. So I don't know how this would be discouraging developers again.
But we're talking about the sale of. So why you would think that you developer,
I
yeah,
was just
no, I'm
referencing
that
that.
the you is the global you, what person would. You know, if someone wants to take a piece of city property that is no longer going to be owned by the city. You know, and it's a bigger chunk, I think we should have the
If they have-
unanimous,
Well, I agree.
yeah,
I agree.
but I mean, I don't think we should be too concerned about a developer who sees a parcel of land who wants to come before the city, why that would discourage him at all. Discourage him by saying it's not a good project, I don't think I can sell it.
Well, I mean, you could end up with a commission where one person runs a very strong anti-development.
We had 3 people that ran on it, and it had no impact.
No, but you got one person that runs an anti-development platform. And they basically say, I'm not voting for the sale of any property, 0, none. They could say that, not doing it, there's enough development, too much traffic, too much blah, 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 not voting to sell any more city property, none. 0. So under 5 million, they can get 4 votes, and they could do that, but over 5 million, that guy's voting no, or woman's not voting, that's the end of it, nobody, you know, so. If that's the result we want. One person can stop the purchase, that's for sure.
Well, since it's sale of public property, I don't have a problem with that. Because the worst thing that'll happen to the city, then it just retains the property.
Is there a size that we do want to reference here? Because I think that Paul sort of said that the 1 million square feet is exceedingly large and probably not the greatest benchmark, given that the $1 million of value is a far more real national return.
$1 million value today is a tiny parcel of property.
Yeah, also, I would say that $1 million in value is subjective.
Yes.
$1 million square feet is objective.
That's why I'm thinking we probably do want to reference a size, but one considerably smaller than 1 million square feet.
Because different appraisers could differ on the value of the piece of property. So you could have one appraiser say it's over 1 million, another person say it's under 1 million. No, no.
But the objectivity comes back with what the city's going to sell the property for.
It says. Right, the approved any sale of approved real property exceeding. Where the revenue, so you're saying that the $1 million is the revenue to the city
Yes, it's the sale
exceeds
price.
$1 million. With a sale price, that needs to be clarified.
Okay.
That's what you're saying.
Yes, and I'm saying,
It's not an appraised value, it's the actual, it's the sales price. Exceeds $1 million.
that becomes objective then.
Yes, I like an objective standard rather than subjective.
So if I may, then the contract would be tentative, I guess. Because whoever negotiates the sale,
Well, any contract that goes to the city commission is gonna have a dollar amount in it. And if it's under $1 million, it requires 3 votes. If it's between $1 million and 5 million, it requires 4 votes. If it's over 5 million, it requires everybody's vote.
so based on sale price.
That's objective.
Yeah, I think so.
Harrison, do you feel like we should have some square footage taken?
I just think that it's a good idea to have that in there, just because I think that, again, not that this would likely happen, but good. If they can't get the votes necessary to sell for $1 million, then they agree to a price of $999,000.
Aha, aren't the developers sneaky?
Then we have the list. Thank you, Devin. It may be.
Found it?
I think I have the list.
I tracked it to July, but.
July 27th.
Yep, the list is interesting, but the values, those properties are gonna change. It's interesting.
Thank you, Devin.
You're right, Harrison, they could lower their price.
Here it is. Here's the
But
property.
then the city doesn't have to accept it either.
I know, but if there's tomfoolery going on and
Never.
it's over $1 million, it's $1 million, it's $1 million to sale.
Mhm.
And the 4 commissioners, or the 3 commissioners that are in favor of it, say to the developer, you know, lower your price to 999,000, you can get it with, they might do that.
So it might,
You're right.
No, Harrison, or who said that? Tom Harrison was the one who came up with the tomfoolery.
Yeah. He's probably seen more of this than us.
I know, he's at the counter. Seriously, you know, somebody fool around with it. It's like that. I mean, I know it's unheard of,
I would be totally shocked.
Right.
I
The
mean, it's
city
like,
would never
what-
license a 100-year
we would
property
never
for $1
license
a year.
property, never to get away from circumvent the charter that required and was voted by doing a
For
lease.
the record, I'm blissfully ignorant of what you're talking about, seriously, so I'm very happy about it. Okay, so
I mean, we're
How do
closing
we-
a loophole by putting licensing agreements to have to meet the same terms as the lease.
I know,
So
but we're
that-
done with that now.
No, but what I'm saying is, it goes back to the same theory.
Yeah.
We don't want to leave one loophole again to circumvent the intent.
Well, then you can do it by doing what Steve Harrison came up with.
Well, I do think that we either maybe want to put appraisal language in here because I think it's a lot easier to determine that something's appraised value is above $1 million rather than the sale price that's going to be negotiated by the parties. And while I would like to incentivize.
There's, but you can, there's, it's like MAI, made as instructed appraisers, that's what it stands for. MAI is made as instructed. They're seriously, appraisers, look at the issues that we had in 2008 where people were over appraising property and stuff like that. You can't, appraising.
Pat Riley, do you have a thought on this that you want to contribute?
Well, you have to, it's kind of a tough decision. You have to kind of look at everything. I think if you try to put so much restrictions, I don't know, it just, I don't know. I'm not really, don't really have a good thought on it, but I don't really, like Mr. Weiss was saying, there's a lot of things that can happen because of this or that on the situation, but I don't know. I really don't have a good thought on it. I have to be honest with you on that.
And Anthony, does this have any impact in like a CRA district, whoever's left of CRA property? CRA lands?
Well, city property is finite, and I think the restrictions are valid restrictions, because the larger the price, the bigger the chunk of the city that's going to be lost, forever. We don't make anymore.
Well, and isn't it a separate process? Because we usually, like, if we're going to dispose of property through the CRA, we'll usually transfer it to the CRA, and it's done separately anyway. We do that all the time with property over there, spur development, because it gets us around some of the other hurdles that we have in the charter for disposal of property.
Well, if the property is transferred to the CRA, does this still apply?
CRA is a public bond.
I think that would be to public, not private.
No, I'm not talking about that. I'm talking about when the city transfers property to the CRA, and the CRA sells it.
Oh, sale by the CRA, I don't think so.
Yeah, it's not applied so
Think
far.
so.
We use it as a mechanism to help the CRA convey property to potential redevelopment.
Isn't CRA the entity of the city?
It's a separate entity.
With the same board.
Same board.
Same board, yeah.
Well, same members,
And
but they
same
function as a
district.
separate board,
Yes.
right?
Questions, so you don't think
I
they're
don't-
subject to these charter?
I don't think so. I don't think so. I can look further, but I don't think so.
I'd be shocked if it wasn't,
Yeah,
because
I
we've been
don't
doing
think
that forever.
No.
But that's certainly a way around it. All they have to do is just transfer the property to the CRA and the CRA. can
Well,
sell it
within the
for-
CRA boundaries.
Yeah.
Yeah,
Right.
so not,
So,
yeah.
Madam, so
Yes.
FYI, I'm seeing.
I'm sorry. David, did you have something?
I was gonna say that you still have to have approval to dispose of it.
Right,
So,
it has to go to the board.
so
and
again,
Separate process.
It's just kind of like,
Video. So what he's saying is, even if this doesn't apply in that respect, you still have to convey it to the CRA, then it goes to the CRA board, which is the elected officials to vote on.
Right, but if they want to sell some, if three of them want to sell property that they can't get 4 votes for, they transfer it to within the CRA, they transfer it to the CRA, and then they take the 3 votes, they sell it.
Well, true, but I think looking at what is available in the CRA boundary itself, I don't know that that's really an area that would generate the same concerns that are causing this conversation in the first.
To give you a sample, I'm seeing on the list here. Totally short about it, I'm seeing amounts, and I'll give you round numbers. I'm seeing numbers like 18 million, 13 million, 10 million, 38 million. 1.8 million, 2.2 million, 2.7 million, 2.6 million, 21.6 million. 3.7 million, I'm just giving you a sampling. So some of the there are a few that are up there. 1.9, 1.3, 326,000. 2.3. There aren't many of the really big ones, but there are some. 8.5, 3.8, 7.2, 1.3,
Some of those are-
30,000.
But some of those are assets, right? Because when you scroll over, it talks about what they are. So like the main filter building at 5
So
$13 million,
what's the
right?
38
It's
one?
not-
38 is. Downtown parking garage,
Right, so it's probably.
so that's land
City
and
park.
land and the garage, that's both. 38.7. And there aren't that many of those big numbers. There's 21 million, that's kind of where I got the 1 to 5 and then over 5.
I don't think the
And it's
issue,
random.
I don't think the issue that's troubling us here is the numbers. The issue that's troubling us is, the issue that's troubling me is the one that Harrison brought up, and the question is whether there should be some square footage on it.
I mean, if we have something appraised for close to 1 million and we know the square footage, maybe we can use that as a good heuristic.
I know, but the charter's, gonna be 5, 10, 15, 20, and it's gonna go on,
Like
so
2050.
something that's was worth $1 million, 10 years ago is worth a heck of a lot more today.
Do you want to hear some square footage?
Not really. It's not really the issue. What do you want to do? I don't really know what to do here.
I do like the idea of having another objective measure in here. Square footage does seem to make sense as seeing that it's real and really hard to kind of.
But it so when you look at property throughout the city, it's gonna have a different value based on the location. So I'm just throwing that out there. I don't know how that would influence the numbers when we move from downtown to the north part of the city.
Right, something that's worth $1 million in some less desirable areas. It's gonna be worth a lot more if it's downtown.
Right.
And then you have the question of what improvements are on the property. Right, because you can have a small parcel with a very expensive improvement, and then. Yeah, I think square footage is a very difficult.
It lists, exactly, has building value, contents value. Total insured value.
On one hand, you could say, you know what, being overly protective, we're not gonna lose. If you're overly you're overly strict. There's, being overly liberal. Where there was some concern that people expressed that the city was selling property that it shouldn't be selling. So,
I agree, just use those thresholds and. We're only recommending it to the city commission, who knows what they're doing.
okay, what you could do is instead of using a number. But of course, they can do the same thing, but it's a property value, the sale of property between 750,000 and 1,200,000 requires 4 votes. And that, there's, as opposed to giving a number, that you give a range, but I think it does the same thing at the bottom of the range. Somebody could just say, okay, 749,000.
There's probably no way to prevent people trying to get around it. If there's available vehicles, you just have to make it harder for them to do that. And as you said, the CRAs are not, you know, throughout the city, there's only certain sections that are CRAs. And those are probably not the areas that people are really, you know, gonna be up in arms about.
Most of the property that we own in the CRAs is already developed. There's not a lot left
I was gonna
over.
say.
If we had more time, I would really get some input from people on this.
Well, it does not have to be a final issue for this ballot, and we can continue.
Maybe it doesn't, you say that we just put this issue off until the next report.
Correct.
I'm fine with that because I don't know, I mean, I usually know how I think about things, but I don't know the right way to think about this.
And again, goes back to my concern about too many ballot questions at one time.
I move we not deal with the system.
I'd like to deal with it if we could, because public lands is a big issue with a lot of voters.
Okay,
And they feel that
I'm happy to deal
the
with it.
city
but I
is
just-
disposing of public
I
land.
just don't know how to deal with it.
There's not a second, I guess.
Is it a motion?
We're just.
If you put your thresholds in, as you said, that is a protective mechanism. It's not foolproof, but it's better than what we have now.
What do you think?
Well, I'm thinking that if we have this maximum insured value for these parcels, that isn't a sale price and it's not necessarily, I don't think it is the same as appraisal, but it's definitely an internal figure to the city. And one that, again, if somebody were to say, I want to buy the executive airport, and I've got the capital to do it, the city has a much stronger idea of what we currently have risk management ensuring the total property.
But I would, before I would go with something like that, I would like to know, with no disrespect, how diligent risk management is, how often they look at these numbers, how often they're checking to make sure that things are properly insured. Are these numbers 30 years old and they just sort of keep rolling over, as opposed to being reviewed like you would your.
And based on that, I'm very familiar because the property appraiser's office previously sent me almost a year ago a whole group of letters where they sent to the city to be updated as to whether or not the city still owns the property or not own the property, so that the right appraisals can be done, and they get no response back from the city.
How up to date do you think these insurance?
I was gonna text Guy and see if I can get an answer for you.
What about vacant property?
So-
That's not
so-
insured.
I don't rely upon the.
Well, they might have some, they would have not, they wouldn't have, they could have liability insurance. So if
That,
somebody,
but liability has nothing to do with.
No, with value.
Yeah,
Hmm.
you're right.
because, yeah, you have these vacant lots and have no insured value and you can't insure dirt.
You have a very good point.
This list is from a year and a half
Yeah.
ago. That I have.
Yeah, because insurance policies also have core insurance clauses too, to protect themselves for undervaluation. A lot of people take the risk of undervaluing because they're saving on premium, so that's not a.
Yeah, we don't even know what the city's criteria is for setting its insurance. I mean, do they fully insure every single building? I don't know.
But we're self-insured up to a retention, and then we have insurance above that, I believe. on
So, and
property, I
then
believe.
I also think we have insurance on.
You have a blank, like a overall policy for for city buildings, and then
Honestly, I'm probably not the authority to talk about it. I know we are self-insured. I think like Paul said,
Up
up to a
to
certain,
maybe,
and then we have something.
Actually,
are you self-insured for damage or are you self-insured for liability?
I believe both.
So what happened with the city hall? It was flooded, right? So what was, that was an example of
Yes, and some of that policy was going to be used to help with the demolition costs, I believe, but a lot of it was provided by FEMA because of the way.
Was the city hall fully insured?
I think so, yeah.
Forget about FEMA just for a second. Was it fully insured by insurance?
I believe so.
And
Yeah, now the city's gonna find that the amount of insurance will not equal the amount of that reconstruction.
Yeah.
unless they, maybe, I don't know if they have it for commercial buildings, if they have, rebuild, what's it called? Replacement costs.
No, generally, commercial, you're gonna have a fixed fee. As I'm saying, I'd be very surprised if the city hall was built for its replacement costs.
Well, there was an
Insurance.
there was an issue that there was a question of whether it would be replaced or repaired, and that had a bearing on the insurance recovery. And
Yeah, and the numbers.
That's
didn't
the
align
lower
in
end.
terms of what you're saying, what we're getting from it would not have replaced.
Right, and I'm sure the insurance company's gonna say, well, you can rebuild the building at a cheaper cost than knocking it down, and building it back again. Restore it.
Anthony, was it that repair would have yielded a better insurance recovery, do you recall?
I think one thing was bringing it up to the new building code was a major cost that was making it not the way to do it.
Yeah, we
Most
couldn't
policies
have
do
it
not
because
insure upgrading to.
we would have crossed the 50% threshold easily. So-
Which is the same problem that we
But
realized.
that's the problem with insurance,
exactly.
insurance is not gonna be a good.
Chris, I'm with you that I think it's important to protect city property, but I just don't know what the right thing to do here is. I agree, I agree with you. This is an important issue and people want it addressed, but I don't know what to do with it. I mean, we could not punt, but say, okay, up to $1 million, it requires 3. Oh, between $1 million and 5, it takes 4, and over 5, it takes 5. We could just say that.
Make a sale price though, rather than.
Yeah.
I think the problem that you raised is a real one. All you need is one naysayer.
Right.
Who's going to prevent, so maybe we just keep it at 4.
So anything over $1 million requires 4 votes.
That would eliminate the
One
naysayer.
person being out the block.
Yeah.
Okay, I'm all right with that.
Okay.
Or with the two.
That you wanna make
What
a
about
motion?
square footage?
Yeah. Do we have to have a public purpose for? You sound like, I guess.
Yes, everything the city commission does needs to.
This is sale to private, so
I know, but it's.
so not really. This isn't where the public purpose comes in.
I mean, take the city hall side with
Right,
they have to purchase it and build
Selling
that
the
apartment.
properties in the public interest.
Yeah.
There's no public purpose to the use of it, that they could turn it into a bar, but they have to, in order to, the city commission has to believe there's a public purpose. to
Well, you
sell it.
did say that in one of your drafts,
Yeah.
it says when one of your thresholds, but they all end on sale would be in the city's.
In the city's best interest.
I mean, I think every action that the city commission takes has to be that. All right.
So, Jim had asked, have we settled on square footage even being included, or do we want to just make this clean and say above and below 1 million, 4 votes is the threshold? Because I do think that's a lot cleaner, and I think that's probably more palatable to like the electorate. Not that I'm basing a lot of my concerns on that, but I think that square feet certainly makes sense in theory, but I also have to admit my limitation on this.
I don't
just
know what
have
makes sense. All right. So you want to do it that way, 4 votes, up to $1 million, 3 votes, over $1 million, 4 votes. I'm up. Judy, how do you feel?
I'll adopt that. I'm fine with that.
That's right. Okay. All right,
I'm fine with anything that's free.
Well, let's, you raise something, do something.
Oh, what?
No, let's think about it. City has been involved with transactions that are a lot more significant than $1 million.
Yes.
And if we get to a threshold, and I don't know what that threshold is, but let's say someone comes in and wants to spend $50 million or $100 million, then maybe we should have some unanimity, because this is gonna be a significant impact on the city.
So in other words, take 1 million to 50 million
Mhm.
and say it takes 4 votes. But if it's over, I mean, I don't even know the number to put on it. It's like an arbitrary, who knows?
And that's, well, million's an arbitrary number too. All numbers are arbitrary, the thresholds. And that's for,
The idea of one commissioner being able to hold up something, I don't particularly love it.
no, in this context, if we're talking about sales of parkland and stuff, I agree with that, but
Parkland's,
yeah, I agree. Just a thought, I was just throwing it out.
Pat, are you comfortable with what we're saying?
I mean, it's just a decision, but I think the more requirements you have on how many people need to pass for it to pass, I think it's tough when you go to the 4 4 out of 5. That's a tough one. I don't know how many things will get through or, happen if it's, because there's always gonna, to me, seem to be someone might not agree with it. So, I could, be a lot of time spent getting it ready, looking to do it and wanting to do it and research and analysis, and then, one vote, if you have to get, if you get past that 3 out of 5 is not enough, then you run that risk, I think, a lot of times that you'll never get it through.
I think sale of public property I think it's appropriate to have a special vote. Yeah, I think 3 is not. And I think 4 votes doesn't give one person the ability to, but if 2 commissioners don't think it's a great idea, then maybe there's something wrong.
I agree with that.
And better than that, better to do it that way than in other municipalities where they say it has to go to the voters for the voters to decide.
I'd
So
also say this, any sale of public property requires 4 votes. See you later.
I'm fine with
I'd be
that.
fine with that too.
But maybe that's too.
I'm just gonna raise those de minimis properties were, well, but that's not the private part.
Well, it could be a private part, there's an alley, some little piece of property, but if there's I don't know,
We do have a lot of leftover parcels.
right, but why would somebody, if it's a checkoff item, why wouldn't everybody have a problem? Why would anybody have a problem with it?
I agree with you. That's my point.
It's just a
We have
small
lot of
piece,
properties.
fine, so it takes 4 votes and,
We sell to the neighboring property owner to do whatever you're gonna do, and those usually little slivers of when replatted properties happen. or
that would be
sold
very
off.
simple. You don't need any thresholds. Any sale of public property requires 4 votes.
I second it.
I'm not going to question, I'm just chit-chatting. I'm at the chit-chatting phase.
I think that makes sense. I think that is probably the strongest and reasonable requirement that we could put on.
Then you can't, there's no fooling around with
That's
the
a good
number,
idea. There's no.
right? You can't, any sale of public property requires 4 votes.
I think that's fair when you look at the future costs the way of
It
variable.
doesn't have to be adjusted for inflation. There's no tomfoolery going on.
Inflation, recession, doesn't matter.
No, it's just any,
No appraisals.
no appraisals, no nothing. If it's any sale of public property, 4 votes. And if I sort of feel like if 2 commissioners feel that it shouldn't be sold, maybe it
And
shouldn't
there's
be
something,
sold.
yeah.
All right, maybe that's a good solution. What do you think?
I like that.
Okay,
too.
let's do that.
Motion,
If you like it.
I move that any sale of public property to private interests requires 4 votes.
Second.
all in favor?
Aye.
Who knows what the commissioner will do with that one? I think
It puts them on the spot though,
I don't want to put them on the spot. I want to give them an opportunity to do good for the city. Okay. What else we got here? So now we know what to fill in on the blank, right? Well,
That's a simple one.
very simple. Yeah, it's not too much draft. By the way, what's her name in the city attorney's office that helped me, Paul?
Jennifer LaReggie.
Yeah, I really should go on the record. Does she work for you?
No,
Yeah, I want to go on the record. She was up late. So I don't know what. Maybe you could pass.
She's
that
great,
to the
yeah.
City attorney.
We'll
She did a
make
very
sure
good
that
job.
gets.
What else?
8.09 leases, licenses, sessions and use range from 1 million to not more than 50. As I mentioned earlier, I deleted non-public, the word non-public on the fourth line in order to make it any use. Fourth line.
Okay, we're gonna change this to, what do we change this to? This. Agreements.
Yeah, I have that. Okay, so this is based on your discussion last week. Got rid of non-public, deleted the 5 years for construction.
Let's
Got rid
read
of
this,
the number,
let's read this, because this is really important.
the number of years plus 5.
The city is hereby empowered to lease to or enter into license agreements, concession agreements, facility use agreements, or other types of use agreements collectively instruments with parties. With private parties for the use of any improved or unimproved real property, including airspace over such real property owned by the city of Fort Lauderdale and not needed for city purposes. For a period of not more than 50 years, including any renewals or extensions. Except that the approval of any such instrument that has a duration exceeding 1 year shall be pursuant to a resolution adopted by the affirmative vote of these 4 commissioners containing a finding based upon fair market value analysis of the property prepared by, we're going to have changes to say qualified independent consultant hired by the city, paid by the developer, that such use of the property would be economically, we're going to change all this, right? Paul?
Yes, and we're taking out economically feasible.
In
The property
addition,
would be
including the city commission's consideration of interest that have a duration exceeding 10 years, including any other shall be consideration of a company business viability report prepared by a qualified independent consultant hired by the city, paid for the developer. Each instrument shall contain a provision the instrument not be assigned. Yeah, this is good. We just need to just true it up to what we've discussed today.
Okay. All right, so I deleted the 5 years for construction. And I guess covered everything else.
Right, you always pass out our work on comment.
I'll explain why I've had it.
Anthony Soroka did this.
I,
My partner. So what is it?
I noticed that.
What is it?
What we want.
Okay, and then
Yeah, let's just finish this
the
one.
prohibition of confinement, I added your request. Except upon the vote of 4 commissioners. And next is 821. In 821, I deleted the first paragraph entirely. I deleted I'm calling it the cutoff date of November 10th.
Right.
2004, and added a reference to the ULDR in the last paragraph. That last paragraph came from a 2004 amendment, as I recall. I added referendum in the second paragraph, so it's as approved in a referendum at a special election called. That was added, I believe it was the word referendum.
Can we just go back here for a second? We have the word here at least again, which leads again to session agreement, blah, blah, blah. We have the same problem here that we had in the other one, which is that we need to broaden the term lease, so it's not, it includes other kinds of agreements.
No, I think so. I mean,
Yeah, it's going
Yeah,
to ask that because I don't want that loophole.
yeah, no, it's a big loophole.
Yeah,
See what I'm saying, Paul?
Yeah.
Yeah, license the
I
park.
think that we should, use that defined term, instrument or whatever we're doing, but just to be clear, I would repeat the same language here because. Just to be clear. Anything that we call it.
Well, no. The city shall not sell or transfer. We're talking about the second.
Second paragraph
paragraph.
on the list.
Yeah, that's sell or transfer. Except for an approved referendum. If we're not talking about leasing it.
I was talking about the second to the bottom paragraph. Now it's saying in contrast, the city shall not lease for more than a year.
Okay, I agree with that. I'm sorry.
Yeah,
so
Well,
we-
we're just looking at the second.
Yeah,
paragraph.
lease or license.
Expand that to the other types of agreements, okay. Got it, yeah, this builds on what was done in 2004. At that time, it said it was either sale or lease. Yeah. Okay, and then, I clarified the zoning designation of parks, recreation and open space. Rather than just calling it park, the zone park. In the last paragraph, I actually throughout. I use the actual name of the zoning category. Is that correct, Anthony?
Right, it is. We do have areas of the city that we treat as parks that we cannot zone parks, but I don't think there are areas that we can dispose of anyway, like the street ends, that type of thing.
This section is directed, it relates to zoned park.
Yeah, we're going through an exercise to rezone every park that we can.
To
So-
this
To
category.
that designation, right? So because what happened back in the day, we had parks that weren't zone park. And the city manager at the time, his solution was to just make parks a use in every zoning district. Now we are actually zoning them to parks. I just want to say that there are parks for various reasons. Land that behaves as a park for various reasons, we cannot rezone the park because of legal limitations.
So does that have bearing on this? Is that why the word park was used at the time, I wonder?
But it would make sense because we didn't zone everything parks back in the day. I don't know why, we just didn't, it wasn't the right way to do it.
But it was called, the words were zoned park, so
So moving forward, what will be the category?
Well, according to this, it would be parks, but if it's something that we utilize as a park, but it's really, and they're in weird situations, right? So like the street ends, so the one over on the river.
Yeah.
Next to the house.
Yeah.
Parks had it kind of functioning as a park, but through it right away, so we can't dispose of it that way, and we can't rezone it as.
but it uses the term zoned though.
Right.
So does that make a difference? That makes a
If you're
difference.
using that term zone, you're really only going after the pieces of property that are actually zoned parks.
Should we say zone and designated or used as a park? But then it's. We're pretty broad then.
It is, I don't know that it's really an issue. It's probably a question for a legal analysis, just to look at the ones we excluded. Because when we had the running list for Parks and Recreation, we gave it to the city attorney's office to analyze every one of them to tell us if we could move forward with the zoning or not. So we have that list. We can look at what it is, but I know you're trying to move forward. We won't be able to put that together.
But since 2004, this section has said zoned park, so I don't know if that would have even related to those
Then it probably would.
non-zoned park areas.
And well, and that was one of the arguments that was being made. So I think Mary Ferding and a couple other people had said, let's rezone the parks. So that's why they did it.
But the zoning category though, of parks, recreation and open space is the correct term, right? Yeah. If we're doing,
So are there parks that we're not protecting here?
There were a lot of land that was being used as a park that wasn't zoned as a park.
Right now they are.
But they've gone through, they have the list.
So for instance, Lee Feldman Park, it wasn't, but we had modified it. We put all the equipment on it and everything, and it sat there.
So now it's zoned as a park.
But now it's zoned.
So is there other cleanup items that we need to take care of, or we just have to rely on the commission to? rezone.
I think they've done a really good job of taking.
We're down to like the last dozen or so. 'Cause we were
Is that a
doing-
process
we were
you're doing?
Blocks, yes.
I'm not worried about it.
I'm not worried.
By the time
The
this
zone-
passes and takes effect, you should be.
We would probably be done.
Good.
I'm using the term from the LDR.
Yeah.
Okay. And that's it. All right.
So the reason why
That you passed out this.
I passed this out, because Nate happened to call me in Pittsburgh today and mentioned to me that in the city of Parkland, they were able to take and incorporate because he feels strongly reiterates what I've said, that you don't want to load up a ballot with too many questions. So they were able to come up with some creativity so that some things could be incorporated where it's one ballot question that actually cleans up various sections of the charter at the same time.
Yeah.
So I want you to take a look at that, or all of us take a look at that, bring in some thought. I also liked on the, as the agenda summary, something that we should also include on our white paper, where it clearly states the board's recommendations are non-binding. The city commission shall have sole discretion to determine which amendments, if any, it places on the ballot, and the final wording of any amendments and the timing of any election on the charter amendments. And I think that's important because there are individuals, again, that are naive in what they think we're doing versus reality.
You want to put something like
And-
this on our,
Yeah, I just think that it's important to incorporate.
the board's recommendations are. What each, so since it's our. Report, we just have to say. Well,
In our report, just so that there's a little, for the public knowledge or how we post it or
so
we
we
have it on
should
the
just
website.
say, maybe in a footnote.
Yeah,
just say,
and I'm fine with that.
Recognize, the
The
board
board recognize
recognizes
that its
that.
recommendations are not binding, the city commission, so it's, right, so let's write a little footnote.
Footnote.
Yeah.
But that's great.
There's different individuals that have been making representations as to what our role has been, and I want to constantly reiterate that I know Jim has mentioned it numerous times at meetings, but there are certain individuals that still try to misrepresent the work that we do here, including the opportunities for public input. And this one, there is no discussion. The other question was, and Richard, when they did this, is there any way or any of the language that was included in this that we need to be cognizant of, that we can also incorporate?
That's yeah, assuming the commission wants to put all this up in the ballot, the next step is the city attorney's office is going to draft something like this, which is, it's an ordinance, a resolution, and then they're going to draft the ballot language. So it'll be up to them to draft the ballot language.
To bring it back.
I actually already have it started. You want to see it?
No.
I have it right there.
Very nice. Very, very nice.
With blanks.
Just-
Resolution, there's a resolution
And
and there's
then-
a proposed
And
ordinance
then
as well.
once the white paper's done, to have it posted on our website as well.
Yeah,
So
Isn't-
that's it.
There'll be a resolution calling the election and then there's an ordinance, just like the park number.
so can we make a motion?
And one last question, probably Jim, you were asking about the Council of Civic Association. Is going to have the meeting what day?
Oh, gosh,
Is it May
May. May 14th,
14.
yeah.
May 14th?
May 14th, right. So time, we figured about 45 minutes or so. Would interesting question.
And I was just going to recommend that we, if the board sees fit, that we designate Richard if he's in town.
I really don't. When is it?
Tuesday, May 14.
Probably busy.
Since
parent.
you work the closest with the city attorney's office on this. And you're more innocuous to the members of the Council of Civic Associations.
Yeah,
And Jim, it
The
could
reason-
be via Zoom, right? The
It'll be,
speaker?
it'll be a blended meeting.
Really. Just really just. Large bodies, I just. I'm happy to work with
Sounds good.
We'd be very disappointed. We would be very honored to
Yeah, but I
have you.
really don't want to.
Simply because you're an impartial party that no one knows, and they would not be able to, some of the participants would not be able to say that was a political move. She's associated with a particular.
How about Anthony?
I'm happy to do it.
Great.
That,
You like
that's, well, I'm
That'd be
happy to
great.
find out this right
I
way, but I'll do it.
Great.
Equally fantastic.
Perfect. There you go.
Yeah,
Congratulations.
Yeah,
Thank you.
I'm fine with that.
I really
Yes,
don't.
yes.
I
Chris,
really-
you,
I
Your
think
thoughts on
Chris? How about Chris? Chris
given
is
my
good.
wife is very active in the community.
Forward.
I wouldn't want
Yeah.
Harrison into that with the work.
What about Harrison?
I'm happy to go.
Let go, present.
Oh, yeah.
Okay.
I can present with you if you'd like. Or
Oh,
be there. I'll be there. if you'd
I
like.
think that would be great, the two of them play off
Yes,
each
great.
other.
Because in
I
that.
think Harrison could talk about his experience as a county employee as well, and his knowledge and his work he's done on the Hollywood charter as well.
And if there's technical questions, you can weigh in on those technical questions or give your perspective. So I think that accomplishes a whole lot. Boy, we got lucky.
Sounds good. What's the actual location of the meeting?
It'll probably be
Zoom
Fire Station
explains
too.
it.
We'll send it to you.
It's gonna be
It's
looking.
downtown Fort Lauderdale.
Harrison, I'll make sure you get
I'll get you all that.
How
I'll
to-
get you.
Yeah, I'm here. I can-
Jim, you could send to me and I'll make sure that it's on both Anthony's calendar and I'll forward it to
I'll have
Harrison.
Barry put it on the agenda.
Okay.
And then we can move forward now as to
Start
two
meeting
you
and
being
the rest of
presenters.
stuff. People
Okay.
reader.
I'm gonna send you
So
their
the commission
names
does
right
this stuff.
now, so you can have it.
Okay.
I'd like to get some direction for the committee as to what we're like moving in the right direction.
Yeah.
I had a thought, I don't know, if you were talking about the amount of items on a ballot, and I've been thinking about that since the last meeting. The sensitivity, it's a big election, right? There's a whole lot of things on the ballot that are, in most people's minds, much more important than this. This is like, what is the city charter? So if you were trying to combine things, maybe you could have three items, combining all the threes, 4 and the 8. I don't know if that's feasible, if you can do it in.
It doesn't really apply to cities, but there are some limitations imposed by the courts about, it doesn't really. Technically, it doesn't apply to cities where you have to have single ballot question. You can't say, do you want to, trying to think of your prohibit abortion, improve the Everglades, and increase the governor's term. You can't like combine, because it forces people to vote one way or another. But, like if it's cleanup stuff, we wouldn't have to have a ballot question for every one of the ones that we're eliminating. We would just have something like, do you vote in favor of eliminating unnecessary provisions from the or something like that? But Paul, do you both?
The last go around, I believe we combined some of the
You said we
issues.
did some
We
cleanup
had two
language.
we only had two questions.
We have a lot of different subjects here. There's one, maybe you could use all the ones on property. But
I agree, I agree with you. Just
Or-
by the
or
new
for the
sections, the 3s, the 4s and
Because
the
that
8.
would, that would consolidate it, and I think, I don't know, I'm not an attorney, and I'm kind of an office, but I'm thinking it might work. Because the appetite, when people look at that, is gonna be, let me get the big things done, and this is at the very end, if they even get to it. So it's a really critical thing to the city, but the easier you make it, the more response you're gonna get.
And again, it goes back to the special act is something that was legislatively done, so it states, so we're pulling things into consistency of the state law and working on that. So I just think it's something.
I move we adopt this report as we've amended it. And the articles that we've amended. And direct Paul to finalize the report, call it Anthony to finalize the report and send it off to the city commission. That's my second. Well, you look very, very.
Who seconded?
No.
Second.
At the same time.
Harrison, okay.
Aesthetically, you like the way it was?
And all in favor?
I'd rather.
All in favor?
Aye.
Okay.
Nice, very good.
Um,
Oh,
Well, go ahead.
sorry, at the risk of
This is like Columbo.
Can I, at the risk of belaboring something, on 8.04, there are additional subsections which we really didn't. There was some existing language.
What's the substance of it?
This is sad, so there is. If you scroll down. Go down to C and D. There is exchanging property. There is paying real estate commission.
We're just gonna vote. We're gonna vote on the sections that we talked about. It doesn't prohibit us from going back, because we never went over those sections carefully. It doesn't prohibit us in the next round of going back to the same article again and changing things. This is just.
Oh, but there were some changes in this, like it was in subsection C, for example.
The city has had the practice, and it's been in the charter, that, I know I went through this with the Marina project, of who pays the real estate commission fee, that the city has the real estate broker who pays the commission fee. Is that where you're,
Well, just
Referring
are
to
you okay with
Recall.
C and D on, look on the second page
Second
under
page,
exhibit
12.
12, at the very
Are
bottom.
you okay with the existing language, I guess is the question, and C,
I'm not prepared. I haven't reviewed the existing language and I'm not prepared to change it until we have a chance to review it and discuss it. That's
so
where
then
I'm
it'll go as a package
just gonna go.
with the section.
We're not re-adopting the section. All we're doing is making the changes that we've talked about. And if there's language in there that we need to go over at a later date, right?
Okay, there was a slight change in C, changing publicly owned lands to real property owned by the city. And there were a few changes, and don't recall,
Licensing,
sorry,
such as licensing.
yeah, I don't recall whether. I think this was actually earlier this stuff, I must have done this pursuant to earlier. I think we're. Right. So there was a.
Do we get, we vote on the.
Yes, we did. Yeah.
We adjourn. We adjourn.
One last thing. After we get done, again, we are a board, we've had this discussion before, so our work doesn't end with this. We get to continue, because there are issues dating back to 2018, we were going to take up next, which is a future discussion on stagger terms. So, those are some issues. So when we talk, that they understand that this is part A of
The
our
first
work.
part of it says we're gonna do more work, and if they don't want us to, they'll tell us.
Well, it's a board, so.
But I put at the bottom of the recommendation, they provide us some food. During the meeting, right? They want us
A budget for food.
He liked it. That's what I told him. He wants it. I just need a budget.
I'm glad you did it because we would have got it.
I think.
All right. Adjourn?
Do we have to discuss the next meeting or is that just gonna be at the regularly scheduled time?
Your next meeting is a regularly scheduled time unless you need another meeting before then. Your next meeting is scheduled for May 2nd.
And when are we going to do, from that one, then we'll do a joint workshop with the commission and go over this so that they can then take action?
David?
I think you're gonna give them a report and they're gonna do whatever they want. If they want to have a work meeting with us, that's great. If not, it's
We're
okay.
fine with that too.
Okay, all right. David, sorry. And Judy was talking about the joint workshop, possibly joint workshop after a report.
But we don't need
Okay.
it if we submit the white paper.
So the idea is to send everything as a communication. And then if they want a joint workshop, the second meeting in May, is that what you want me to try to work towards, or?
That's different. A communication is actually on the agenda. Is that your intent, board?
We're just gonna send the report.
Just
They
send
do whatever they want with it.
Well,
I mean,
because
it's not
that's a
really.
memo through the city manager's office.
Yeah, and then they do whatever they want with it. I don't wanna get involved in their
Send it as a
scheduling.
report?
Send it as a memo, a report attached to a memo,
Let's
city manager's
Once
office.
they get a
Okay.
report, if they wanna schedule a
mimic
meeting,
some of the
that's
language
great.
in the-
If they don't wanna schedule a
Okay.
meeting, then fine.
All right, so it's not-
Give it to them.
Whatever. I don't wanna presume to tell
That'll give us the
them.
opportunity to talk about it at the commission meeting anyway. So somebody can bring it up.
But it doesn't sound like they want it as a formal communication.
No, I know, but if we send it as a memo, they'll still have the opportunity to bring it up and talk about whatever.
Of course.
Okay, you heard that, David?
Yes, and just if they do decide on a joint workshop, I would just say to look at your calendars for the second meeting in May. As of right now, there isn't a workshop on that day, and I believe they're going to have I don't know what the term is for a groundbreaking for taking down a building, but they were supposed to do something for City Hall at the first meeting of May, so it would be the second meeting in May if they were going to do a joint workshop.
What are they gonna do, take it down and build on the one-stop shops, since that?
All right.
Always
let's
the
make sure
big-
that the hearings.
That'll change this list.
I have a question. You're not.
Very well, thank you again.
Likewise, Richard,
Make
thank
sure
you.
that woman in the attorney's office, make sure Tom knows. I sent. But I think it was now.
That's good. Anyway,